Italian nationality law is the law of Italy governing the acquisition, transmission and loss of Italian citizenship. Like many continental European countries, it is largely based on jus sanguinis. It also incorporates many elements that are seen as favorable to the Italian diaspora. The Italian Parliament's 1992 update of Italian nationality law is Law No. 91, and came into force on 15 August 1992. Presidential decrees and ministerial directives, including several issued by the Ministry of the Interior, instruct the civil service how to apply Italy's citizenship-related laws. Acquisition of citizenship. Italian citizenship can be automatically acquired by birth to an Italian parent in line with the principle of jus sanguinis, by birth in Italy to stateless parents, to unknown parents, or to parents who cannot transmit their nationality to their children. This is partially consistent with the principle of jus soli, with the acknowledgement or legitimation of an Italian mother or father, on 27 April 1983 by minor children without Italian citizenship, including children legally adopted per Italian law, who as of the same date had a parent holding Italian citizenship, or after 27 April 1983 by foreign minor children legally adopted by Italian citizens per Italian law, by some former citizens of Italy, after 2 years of residing in Italy. If the original parting with Italian citizenship was caused by naturalizing in another state, the Citizenship Law 555 of 1912, discussed later, carried the pertinent provision until it was superseded by minor children of persons acquiring Italian citizenship. Before 27 April 1983, minor children could not acquire Italian citizenship by this means if they were living abroad from Italy and still retaining a foreign citizenship, by Vatican citizens concluding their ex officio Vatican citizenship who would otherwise become stateless upon this event, pursuant to the provision in Article 9 of the Lateran Treaty of 1929 between Italy and Vatican City. Through special application, the applicant must have served in the Italian military or civil service or have resided for 2 years in Italy after reaching the age of majority. For individuals who were born in Italy to foreign parents but who have resided in Italy continuously from birth to adulthood, through marriage, foreign women who married an Italian citizen before 27 April 1983 were automatically granted Italian citizenship, after 2 years legal residence in Italy, or 3 years living abroad. This time will be reduced by half if the couple have children. The spouse of an Italian citizen can apply for Italian citizenship through naturalization. Through naturalization, a person who has been legally resident in Italy for at least 10 years may apply for and be granted naturalization as an Italian citizen if he or she does not have a criminal record and has sufficient financial resources. The residence requirement is reduced to 3 years for descendants of Italian citizen grandparents and for foreigners born in Italy, 4 years for nationals of EU member states, 5 years for refugees or stateless persons, and 7 years for someone who was adopted as a child by an Italian citizen. Attribution of citizenship through jus sanguinis. Citizens of other countries descended from an ancestor born in Italy may have a claim to Italian citizenship by descent. Italian citizenship is granted by birth through the paternal line, with no limit on the number of generations, or through the maternal line for individuals born after 1 January 1948. An Italian citizen may be born in a country whose citizenship is acquired at birth by all persons born there. That person would be born therefore with the citizenship of 2 countries. Delays in reporting the birth of an Italian citizen abroad do not cause that person to lose Italian citizenship, and such a report might in some cases be filed by the person's descendants many years after he or she is deceased. A descendant of a deceased Italian citizen whose birth in another country was not reported to Italy may report that birth, along with his or her own birth, to be acknowledged as having Italian citizenship. A person may only have acquired jus sanguinis Italian citizenship by birth if one or both of that person's parents was in possession of Italian citizenship on the birth date. There is a possibility in the law that the only parent who held Italian citizenship on the birth date of a child born with jus sanguinis Italian citizenship was the mother, who previously acquired the Italian citizenship by marriage to the father, who relinquished his own Italian citizenship before the child was born. Under certain conditions, a child born with Italian citizenship might later have lost Italian citizenship during his or her infancy. The event could prevent a claim of Italian citizenship by his or her descendants. If the Italian parents of a minor child naturalized in another country, the child may have remained holding Italian citizenship, or else may have lost the Italian citizenship. The children who were exempt from losing their Italian citizenship upon the foreign naturalization of their parents were in many cases citizens of other countries where they were born, by operation of the jus soli citizenship laws in those countries. One must apply through the Italian consulate that has jurisdiction over their place of residence. Each consulate has slightly different procedures, requirements, and waiting times. However, the legal criteria for jus sanguinis citizenship are the same. Basic criteria for acquisition of citizenship jus sanguinis. There were no Italian citizens prior to the 17th of March 1861, because Italy had not yet been a unified state. Thus, the oldest Italian ancestor from whom Italian citizenship is proven to be derived in any jus sanguinis citizenship claim must have been still alive on or after that date. Any child born to an Italian citizen parent is ordinarily born an Italian citizen, with the following caveats. The Italian parent ordinarily must not have naturalized as a citizen of another country before both the child's birth date and the date, the 15th of August, 1992. If the child had an Italian mother and a foreign father, the child ordinarily must have been born on or after the 1st of January 1948. There have been many successful challenges to this date restriction that were brought before the Court of Rome. In the capacity to determine Italian citizenship, offices in Italian consulates and municipalities are bound by the restriction. If the Italian parent naturalized as a citizen of another country on or after the 1st of July 1912, and prior to the 15th of August 1992, then the child's Italian citizenship survived the parent's loss if the child was already born and residing in a country whose citizenship he or she additionally held because of that country's jus soli nationality laws. Conversely, if the child was not born in a country whose citizenship was attributed to the child based on jus soli provisions in its nationality law, then the child could lose Italian citizenship by acquiring the citizenship of the naturalizing parent. Italy generally does not attribute its citizenship based on jus soli, so an Italian child born in Italy could lose Italian citizenship in the event that his father naturalized. In the event that a person reached Italy's legal age of adulthood while possessing Italian citizenship, that person's holding of Italian citizenship ceased to be conditioned on the subsequent citizenship changes that might occur for that person's parents. So if the Italian parent naturalized as a citizen of another country, then the child's Italian citizenship could survive the parent's loss if he or she reached legal adulthood prior to the parent's naturalization. If the child's Italian father naturalized as a citizen of another country prior to the 1st of July 1912, the child's Italian citizenship was not directly impacted by the father's loss if the child reached legal adulthood by the time the father naturalized, or else if the child was residing in Italy when the father naturalized. Italian citizens naturalizing in another country prior to the 15th of August 1992, while being of legal adult age, typically lost their Italian citizenship at that time. Italy has been a participant in the Strasbourg Convention on the Reduction of Cases of Multiple Citizenship. Children born outside of Italy with the citizenship of a member country may not have been able to hold Italian citizenship by birth because of this convention. The convention has also extended the era when Italians could lose citizenship by foreign naturalization to dates later than the 14th of August 1992, if the naturalization were in a participant country. All conditions above must be met by every person in a direct lineage. There is no generational limit, except in respect to the date of the 17th of March 1861. Note that if an Italian ancestor naturalized as a citizen of another country independently from his or her parents, and prior to reaching legal Italian adulthood, then often that ancestor retained Italian citizenship even after the naturalization and could still pass citizenship on to children. Also, having one qualifying Italian parent, who except in certain situations could only have been the child's father if the birth occurred before 1 January 1948, is sufficient for deriving citizenship, even if the other Italian parent naturalized or otherwise became unable to pass on citizenship. Sometimes that qualifying parent is the foreign-born mother, because foreign women who married Italian men prior to the 27th of April 1983 automatically became Italian citizens and, in many cases, retained that citizenship even when their Italian husbands later naturalized.